All right, David. Interesting dissent from denial. This is a Gorsuch dissent joined by Kavanaugh about, well, it's a special prosecutor case, but it's not the special prosecutor that you think it is.
Yeah.
This was a case where, in fact, the judge held someone in contempt, refers it to the Department of Justice. The Department of Justice then declines to bring charges. And so the judge is like, okay, in that case, I will appoint a special prosecutor to prosecute this contempt case. And the judge continued to be the judge, didn't recuse themselves at that point. And this, of course, made it all the way to the Supreme Court on a cert petition. That cert petition was not granted, but you had Gorsuch and Kavanaugh saying, what the separation of powers, Batman?
Yeah, this case, Sarah, absolutely fascinating. The facts are really interesting because it involves an environmental case that I've kind of followed for a while, kind of at arm's length, fascinated by it. It was a lawsuit brought against Texaco, which is a corporate predecessor to Chevron. We've talked a lot about Chevron in the context of administrative law and administrative law cases, but this is talking about Chevron as in Chevron, the gas station or the gas company. This was a case brought against Chevron. Chevron wanted it removed to Ecuador from New York. Now, this is an interesting strategic decision. They said, no, don't sue us in New York, sue us in Ecuador. They get sued in Ecuador and lose a judgment, Sarah, of $8.6 billion.
Womp, womp, womp.
Yep. And you can imagine me like Austin Powers with the pinky at the edge of your mouth. $1 billion. Okay. So then Chevron is like, wait a minute, this was corrupt. There was bribery. There is all kinds of problems with this judgment. So they've been attacking the judgment ever since. And so they've been attacking the judgment in federal court. And an attorney, the plaintiff's attorney, a guy by the name of Donziger, received an order to turn over, Stephen Donziger, received an order to turn over his electronics. And he says, nah, dog, I don't think I'm going to turn it over. So the court does what the courts often do when you say nah, dog to the court, issues a contempt citation. And then the prosecutors don't prosecute. And then the court says, I'm having none of that. I'm appointing my own prosecutor and then hearing the case in a bench trial. Now, what blows my mind, Sarah, is that the case was upheld by the Ninth Circuit.
There's a lot that blows my mind about this case. Just to be clear, and this is, what Gorsuch and Kavanaugh are pointing out in their dissent from denial, what branch is this special prosecutor belonging to and reporting to? So, for instance, and this I'm now reading from their opinion, highlighting the confused but surely executive nature of the prosecution in this case, the United States supplied the Second Circuit with two different briefs offering different theories. One brief came from the court-appointed prosecutors, another from lawyers within the Department of Justice. As then they later point out, the notion that the Constitution allows one branch to install non-officer employees in another branch would come as a surprise to many. Who really thinks that the president may choose law clerks for my colleagues, that we may pick White House staff for him, or that either he or we are entitled to select aides for the Speaker of the House? Our Constitution does not tolerate what happened here. Nevertheless, it does, because, in fact, they did not have 4 votes to take this case.
Exactly. Turned out there's lots of tolerance for this weirdness. Yes.
And it's not the only weirdness. I mean, we've talked about these separation of powers cases, for instance, in the context of independent agencies or independently funded agencies. There's now the CFPB case that's going to be argued next term. But there are, at the margins, a lot of weird, fuzzy lines. So, for instance, there can be interim U.S. attorneys that are court appointed, in fact. Now, as that works in practice, normally it's someone who the Department of Justice wants to be appointed by the court, but that doesn't have to be. So I agree with Gorsuch and Kavanaugh here. However, it's worth noting that for as high a horse as they are sitting on, this isn't actually so out of the blue or so different than a bunch of other weird things. I mean, for that matter, and I know I am the daughter of a bankruptcy judge. Bankruptcy judges are unconstitutional. Article
Wait a
1,
minute. Does your dad listen?
Yeah,
Does your dad listen?
He does. In fact, he sent me notes on the last podcast.
Dad, you're unconstitutional.
I've told him that. He's an unconstitutional dad. But, there's Article 1 judges, and there's Article 3 judges, and then there's judges within the executive branch. Think about immigration judges. So this idea that we have this perfectly delineated separation of powers sure feels really nice, but in practice, it's not how it's working. Though, again, I appreciate Gorsuch and Kavanaugh standing up and saying our Constitution does not tolerate what happened here. Also worth noting, this guy, Donziger's a celebrity on the left, as Josh Blackman pointed out in one of his posts. So anytime you're looking for justices siding against their policy preferences, if you were, this is a decent example of Gorsuch siding with not just a criminal defendant, but a left-wing criminal defendant.
Celebrity left-wing criminal defendant. Yep. And, I think the thing that just gobsmacks me the most about the case
Love that phrase.
Isn't just that he appointed the attorney to go ahead and prosecute when the DOJ said no. It's that he did it when he held on to the case and it was a bench trial. So it would have been, at least you could say, if he'd had a jury trial. Well, the jury did what it did. I mean, I have no control over the jury, but he said, you got to prosecute and I'm the finder of fact here. It's a pretty remarkable turn of events. And I'm glad that Gorsuch stood up here. I'm glad that Kavanaugh stood up here. And I'm just sad there were not two others, because this is a wild case.
And a little surprising that there aren't two others, but, as has been pointed out, for instance, and again, this is Josh Blackman pointing this out, Justices Sotomayor and Jackson could be expected to go along with a grant on a matter of such concern to criminal justice. But alas, this case involves separation of powers and potentially the non-delegation doctrine. And again, it's not that I think we know how they would have come out if the case had been granted cert, but rather when you've got a really messy case like this, sometimes the justices are just like, I'm waiting for a cleaner vehicle.